So please give us a brief introduction.
So my name is Sushrita Mishra. I passed my 10 and 12 from DAV Unit 8 Bhubaneswar, and thereafter I did my law in University Law College, where I had integrated law. And currently, sir, I'm pursuing my final year in Masters of Law, and my specialization is human rights.
Tell us something about your hobbies and achievements.
So my hobbies include cooking and writing quotes and poems. And so my achievements, if I may quote that, I have participated and won in several national and state level moot court competitions, national trial advocacy competitions, and memorial drafting competitions. And so I've also participated in parliamentary debates. So.
Okay, in hobbies, you can make it more specific. Like you're saying, I like to cook, so or I like to write. So I like to write what kind of poems or exactly. So if you are more specific, then it would be better. Rather than saying that I like cooking, you can just focus on I like to cook these this particular cuisine, right? That would be better. Okay.
Sure, sir.
Yeah, that is what I was also about to tell. That you have to be bit specific. You want continental cuisines. You have a lot of things as well, Thai cuisines or Chinese or Oriya cuisines also. So those things you have to be specific. And for like you told that I love writing poems, all those things. So also in that regarding nature or regarding anything which you are specific about. Now, my question is this your first attempt?
Yes, ma'am.
Okay. So why you want to be a judge?
Ma'am, since I was in class 7th, I had an inclination for judiciary, since the topics of judiciary were included in our social studies book. And since then, I have always wondered how the way they maintain the stature and the way they impart justice without being partial to anything, and nothing can dictate upon them except law. This has always drawn me towards this profession. And secondly, ma'am, as I grew up and I started my started studying law in my law colleges, I became aware that not only law students, but every person in a country must be aware about one's own laws. So to be aware about one's rights and duties. So for this reasons, ma'am, I am really interested for this service, and I feel that by being instrumental to this system, I can do my best to do service to the people around me.
Okay. And God forbid, for any reason you are not able to crack this time, then what will be the future plans?
Ma'am, I'll definitely try to polish my knowledge in the relevant subjects. I'll try for one more time, but at the same time, I'm also thinking to increase my knowledge by doing litigation and appearing other examinations pertaining to law, like the UGC NET and other law officers examinations, ma'am.
Okay. Now, can you tell me that nowadays a very word is very relevant that judicial activism. What is judicial activism is all about, and how it has impact on the present day scenario?
Ma'am, I would like to address this question by stating that in our country, in our constitution, separation of power is a part of basic structure of the constitution, and every organ of the state has its own limits. So within that domain, one has to perform one's duty. So the job of the judiciary is to interpret law and to administer justice. So when the judiciary transcends its boundaries and starts making laws or regulations, in that case, we can say that the judiciary is doing judicial activism. Ma'am, this judicial activism concept has been borrowed from the US Constitution. And ma'am, especially when there is a judicial activism in a proper sense is good. We have this in India as well. Whenever there is a legal vacuum, in that case, the judiciary can step and can make rules and regulation until the legislature comes to its starts doing its duties by legislating on those particular subjects. If I may give some instances, madam, like in Vishaka case, the state had actually given some guidelines for the prevention of sexual harassment at workplaces, ma'am. So whenever there is a legal vacuum, so judiciary has the power to regulate all these rules and regulations, ma'am.
Okay, what are your optionals for this exam?
So my optionals were law of crimes and torts and transfer of property and so personal laws.
Hmm. In hobbies, you have written reading Hindu mythological books. Okay.
Yes, sir.
Then
Yes, sir.
cooking, writing poems, stories. Okay. What I would advise is there are three things which are given here. One is sports. So obviously you don't have much to write about sports. Then comes hobbies. Okay. You choose one or max two, but you have given 4 or 5 here. Okay. So like three you have given in the sense that writing poems, stories. So you choose any one or two maximum. Okay, and extracurricular activities if you had like NCC or Scouts, Guides, whatever, that you can give. So three hobbies generally to interview panelists, it would seem that person has a lot of free time. Okay, so
Okay, sir.
one or two would be fine. Then one in national moot court. Okay, that's fine. National trial advocacy participated in national moot courts. Okay. One national memorial writing parliamentary. Okay, so all are in one particular domain. So, any other achievements from, let's say, any other domain, for example, UGC net, you said you have qualified or you will be giving.
No, sir. I said I will be appearing.
Yeah, you have not completed it. Okay,
Yes, sir.
fine. So those things you can just, okay, human rights, you're doing your post-graduation LLM in human rights,
Yes, sir.
constitution and administrative law. Okay. So tell me something about Universal Declaration of Human Rights and some rights or the major difference between UDHR and Part 3 of Indian Constitution. Some rights which have been given there, but either we have not included here or we have toned it down a bit.
Sure, sir. So UDHS stands for Universal Declaration of Human Rights. This is a multi-party international agreement that was signed and ratified by many nations in order to promote human rights and to preserve human rights and to protect people against violation of their human rights. Sir, under the UDHR, there are several rights that have been enumerated. As many as 30 human rights are there, sir. And India is also a signatory to the UDHR document, sir. So, Part 3 of the Indian Constitution provides for fundamental rights, and almost every right present in the Indian Constitution has been incorporated in UDHR. However, sir, I would like to state that there is one right, that is the right to life and personal liberty, which is there under UDHR as well as in the Constitution of India, sir. However, sir, UDHR has strongly condemned the death penalties and it has abolished death penalty. India, being a signatory to that, has to implement that. However, this has not been implemented, and the constitutional validity of death penalty has been still intact under Article 21 of the Constitution, even though it provides for right to life and personal liberty.
Okay. Can you just compare our legal, position with that you have already said with respect to death penalty and with the position in United States?
Sir, in what respect?
Uh, in respect to your death penalty, like we have in our country, we have death penalty, okay? Maybe for rarest of rare cases. What is the position there in US?
So I probably don't remember it properly, but if you may permit, I may try this.
Yes, you can try.
Thank you, sir. Sir, I believe in US the death penalty has been abolished. However, in India, the death penalty has not yet been abolished. However, in five important landmark cases, the question of constitutionality of death penalty has been raised, and time and again, the Honorable Supreme Court of India has upheld its constitutional validity. But, sir, the death penalty that is imposed in India is backed by a lot of regulations, lot of checkings, and lot of transparency, so that it cannot be given as a matter of right or as a matter of procedure just because it has been enumerated down in certain offenses. So, whenever a death penalty is granted in India, sir, in that case, several checkings has to be made. So, the first case to be noted is the Bachchan Singh versus State of Punjab, in which the rarest of rare doctrine was laid down, and it was said that death penalty, whenever it is given, it must be given only in rare cases because life imprisonment is the rule, whereas death is the exception. And so, whenever a death penalty is given by a court of sessions, it has to be confirmed under Section 366 of the Code of Criminal Procedure by minimum two High Court judges. And after checking that, then only the death penalty can be given. And so, even if death penalty is given, there are certain pardoning powers that has been granted in the Constitution of India under Article 72 and 161, wherein the person convicted and sentenced for death penalty can seek pardon from the president and the governor. And so there are also some commutation power that are provided under Section 341 and 342 of the Code of Criminal Procedure, wherein this the appropriate government can commute the death sentence into life imprisonment. So, sir, having said all these parameters, it can be said that in India we do not follow a blinded rule to give death penalty. Whenever it is mentioned, it is scrutinized at every stage so that to give it only in the proper case where there is actually a need of the art, sir.
Okay, fine. US basically, these things are decided by the states itself, right? 50 states have 50 constitutions. Some states, they have already abolished death penalty. Some states, okay, especially the southern states, okay, they have death penalty. They have no plans of abolishing it. Okay, through lethal injection or through electric chair. They don't have death by hanging, generally by electric chair or through injection of the lethal injection, poisonous injection. Okay. So since you are also studying constitution in your LLM, Supreme Court observed that where Article 31C comes in, Article 14 goes out. Can you tell me what they were basically saying? In what context? It is basically related to the power equation between part 3 and part 4.
So, under Article 31C, sir, there are certain legislation that are brought by the legislature and they're put in the ninth schedule of the Constitution. Thereby, they are refrained from being judicially reviewed under Article 13 of the Constitution. So, sir, whenever a law is to be checked on the touchstone of the Constitution, we have to scrutinize it with respect to the fundamental rights. But Article 31C provides a blanket protection to such laws which have been incorporated by the virtue of Article 31C and which have been inserted in the ninth schedule of the Constitution. But, sir, with the judgment in the case of I.R. Coelho versus Union of India, this has been done away with, and the Honorable Supreme Court has said that before the evolution of or before the introduction of the basic structure doctrine in Keshwananda Bharati case, whatever cases were there, that is 24th of April 1973, those laws which were added in the ninth schedule of the Constitution, they shall be granted the umbrella protection or the protection from judicial review under Article 13 of the Constitution. However, those laws which were inserted under after 24th of April 1973, judicial review of those laws can be made because judicial review is itself a part of the basic structure of the Constitution, sir.
Okay, that is correct. 31C basically, tells about certain laws which, if they're enacted to give okay, effect to certain directive principles of state policy, which are given in Article 39 B and C. Then they will not be violative of Article 14, okay, and also Article 19. That is the thing. But that position has now changed. They have, gone to the extent of entire Part 4. Okay, but okay, fine. So that is okay. Our constitution, there are so many doctrines are there which our constitution follows. Okay, can you tell me if you have any idea about the doctrine of colorable legislation? Doctrine of colorable legislation.
Hello, am I audible, sir?
Yeah.
Yes, sir, could you please repeat?
Yeah, you're audible. Doctrine of colorable legislation.
Sir, doctrine of colorable legislation means what cannot be done directly cannot be done indirectly as well. So there are three lists in the seventh schedule of the Constitution, which provides that the state legislature and the union legislature have to legislate only those subjects which have been specified in the respective schedule. So, if one of the legislature, be it the state or the union legislature, passes any law or enacts any such legislation whereby it indirectly legislates on that subject by which it has been forbidden under the seventh schedule of the Constitution, that law can be struck down by using the doctrine of colorable legislation, sir.
Okay. The government has brought amendment bills for three important statutes. Okay,
Yes,
earlier
yes,
this
sir.
year. Now, just tell me the most important amendments or changes they want to bring for all these three laws. Okay.
Sir, as far as the Indian Penal Code is concerned, sir, in that case, snatching has been included as an offense. Then promise to marry a woman without an intention, a promise to marry a woman and cohabiting with that woman without any intention to marry has also been made an offense thereunder, sir. And so, uh, I don't remember it properly, but if I may say, I think adultery, sir, has been made a criminal offense under this act, sir, which has been made gender neutral. Here, both the male and as well as the female can be prosecuted here under, sir. And so,
What about
whatever, yes, sir.
sedition? Sedition?
Sir, as far as I remember, sir, there is no such legislation in the new law regarding sedition, sir.
Just check that. Okay. If they are planning to keep it or they want to, take it away because your Attorney General had given some statement in the Supreme Court regarding the government is not keen on continuing, the current form of sedition. So just take that, what they are planning to do with the sedition law. Okay. Sedition currently is dealt in which section of IPC?
So 120, so 124 capital A, but since the judgment in 2023, S.G. Gombachkar versus Union of India, the Honorable Supreme Court of India has directed not to file any cases under section 124 capital A unless the concerned government has made out proper laws which can fit into today's society. And so whoever has been booked under this act as far as now can seek for bail under this provision, sir.
Okay, then, so this is about the IPC. Then other two?
So it's CRPC and evidence of, sir, in CRPC, there has not been any major changes. Whatever was there in the act or the code, sir, under section 41A, 41B, 41C, they have just the number segment has just changed. And so the recent judgments of Arnesh Kumar versus State of Bihar and CBI, Satyendra Kumar Antal versus CBI, the cases relating to arrest and bail provisions have been codified in a proper manner. So all these guidelines have now been included in the new act, sir, or the new code, sir. And as far as evidence is concerned, sir, I'm sorry, I'm not sure about it. I've not gone through it. I'll definitely look after it, sir.
Okay, that is fine. So can you tell me, in what circumstances, okay, a police officer Okay, is there any provision in our criminal law that a police officer will get some powers of magistrate?
Police officer. I'm
Okay,
sorry, sir. I
let's
can't
say,
recall as of now, but I believe there
okay,
is a certain provision.
okay. Can a police officer, okay, you know, uh, this arrest warrant, okay, can a police officer issue arrest warrant if
Sir,
the any exceptional in any exceptional condition if he can do so?
So, yes, the arrest warrant can be made by a police officer when the person to be arrested in is at a place not within the jurisdiction of the police station of which he is the police station. So, in that case, the arrest warrant can be forwarded by one police station to another police officer in whose area of police station the other person is suspected to be there, sir.
Um, Normally, so you're saying that the police officer has the power to issue, okay, to issue, my question was to issue an arrest warrant. Can a
I
police
would like
issue warrant, arrest warrant?
Sir, I believe it's only the court and the magistrate which can issue the arrest warrant, and these are issued to the police officer. The police officer, I don't think, sir, if he can issue the arrest warrant, he can simply transfer the warrant to his subordinates or to any other police officer in other jurisdiction to carry it out, sir.
Okay, any provision in the new amendments related to zero FIR?
Sir, zero FIR in the new amendment, it is there, and even before that, this concept was there by the virtue of Supreme Court decisions in Punati Ramove versus State of Andhra Pradesh, and also it was one of the suggestions made by Justice Verma Committee after the 2013 Criminal Law Amendment Act. So, sir, in the current in the new procedural code that has been brought out, the zero FIR is there, sir, that any person who is aggrieved of any offense or against whom any offense has been committed, sir, can file a FIR irrespective of the jurisdiction of the police station to take that FIR, sir.
Okay. How do you generally handle failure? What are the, what are the defense mechanisms that you have against failure?
So, to be honest, sir, whenever I face failure, I really, really feel bad. But this phase is quite temporary. But the way I overcome is, sir, I listen to some devotional music. I sit quietly for some time, and thereafter, I say to myself that whatever has been done for my betterment. This failure is basically a premature form of success, sir. So if I'm facing failure today, maybe I need to effort harder and I need to convert this into success. So, sir, yes, I do feel bad, sir, but I'm resilient enough to come across that if I get a time of 1 or 2 days, sir.
Okay, fine.
Okay, I want to ask you that, like, lot of changes in society, if you see nowadays, like, there are people who are facing cognitive disabilities, like you say they are autistic, they are hyperactive. So these people are much more increasing in number day by day, especially in India. Also, it is happening. Okay, now if a case in your court comes where you being a judge has to give a verdict where one of the accused is facing a cognitive disability, what are the things you should be considering before giving your verdict? And does that criteria will affect your judgment?
Thank you, ma'am, for the question. Ma'am, in case the accused is facing any kind of cognitive disorder, firstly, I need to ensure that whether if that person is examined or cross-examined in the procedure, he shall be able to give rational answers to the question asked to him. So, in case he is not able to answer that, this is which is the very preliminary stage of a trial or inquiry, ma'am. In that case, the case cannot be taken forward, and that person has to be transferred to a rehabilitation center in order to know whether this person can be redeemed or he may be made matured enough to answer questions properly. And in case, ma'am, such person is able to is able to answer rationally to the questions asked to him, I need to ensure that I need to be satisfied that while committing the offense, if that offense is proved against that person having done, I need to satisfy myself that whether by the uh, disability or the cognitive disorder, he was unable to understand the nature and consequences of the act he did commit while he was committing. In case, ma'am, he was unable to understand, there cannot be any kind of conviction. But, ma'am, in case he was able to understand the nature and consequences, then he shall be convicted. But even if, ma'am, if he is not being convicted, thereafter I also owe a duty that in case I pass any judgment acquitting that person, I must refer him or her to a rehabilitation center without giving it to custody to any other person, ma'am.
Do you think that in our rural areas, people were not aware of the laws, their rights, especially the women and the illiterate people? So, sure, what are the steps should be taken by the government or by the NGOs or the persons, social workers, so that the people will be aware of their laws first thing? And do you have hold any opinion of incorporating basic legal laws or basic legal studies to in the school level, so that from the very childhood children should have the basic, not I'm telling the details, but they should have, like in our civics we have certain things about parliaments and everything, so they should be aware of.
Thank you, ma'am. Ma'am, for the first part of the question regarding the awareness among the people in the rural area, ma'am, awareness, the government does owe a duty to aware people of their rights. And since education is considered to be the most perfect medium to impart this to people, firstly, they must be educated at the from the very basic level. And in case this has not been by now, awareness programs can be done in periodical times so that to aware women about their rights, not only women but every other section of the society, ma'am. And I believe, ma'am, social media can play a huge role in awareing people about that, ma'am. If I may say that now people by using or abusing social media are doing many reels or TikTok type of things. So, ma'am, if that can be made a medium to let people know about their rights and duties, they shall be very concerned about it, and they will be very they will be having an insight about their rights and duties. So, ma'am, and the government has to play an important role in that because it cannot be done by any other person. We cannot, it is only the state which has the power to consolidate people for a proper meeting or something like that. And coming to the second part of the question, ma'am, yes, I believe that certain important laws must be incorporated in the educational academics of the students because, ma'am, as I have stated in the very first part of my interview, I believe, and it is a law that every person in the country must be aware about one's own laws. And no one can take the defense of that, I do not know the law, so I must not be convicted or accused of this and that. So, ma'am, education must be there, and this legal education is very vital. Since moral education, sports, and other co-curricular activities have been incorporated, legal education, irrespective of whether a person chooses one's profession to be so, he or she must be taught this from the basic level. And also, ma'am, in many cases where children are very small nowadays, ma'am, sex education is also important so that the small children, they would get to know that what is a bad touch and where to protest. So, ma'am, when they will be given the legal knowledge, they would get to know if any offense is done against them, and they can voice their rights by saying it to their respective guardians, ma'am, about that. So this can be a medium, and this will definitely serve for the betterment of the society, ma'am.
Okay, fine. So that will be the end of the interview. Now coming to the feedback. So um, your eye contact is a virtual interview, but considering the camera, okay. So your eye contact was good. It was not wavering. But you practice with at least 3 to 4 members. Okay, mirror interviews you can practice, and just cross mark 4 cross marks on the mirror. And while answering, just ensure that you look at all the panelists, 4 people or 3 people, whatever. Okay, so the rest other things are fine. Your content is good. You are updated. Okay, and your presentation is good. Flow of speech, which is obviously natural with you. Sometimes it is too fast. Okay, but that is subconsciously you can't really control it. So rather than being conscious about that, you can continue. It is understandable, comprehensible. So again, I could comprehend whatever you're saying. Okay, and another thing is like, yeah, the things which you did not know, 1 or 2, those things you said that I don't know. So be very particular on that. If you're not confident or not very sure of one particular aspect of the answer, that you can just tell them. Okay. So for example, 31C, that basically deals with the DPSP, okay, certain particular DPSPs, right? 39B and C. So sometimes, so if you are like not very sure, then you can ask like, to guess or something which you asked, I think, once. So otherwise, other things are quite good. Okay, so I'm expecting that you'll get a good rank, at least good marks in the interview. So I have given you 75 out of 100 for today's interview. Okay, ma'am.
Yeah, your flow of speech was good. Presentation and clarity of concept was also convincing and good. What sir told is that you cannot control your speed. That happens. Okay, but what I feel like I am not doing a face-to-face. Yesterday, I told one of the children or student also the same thing, that sometimes subconsciously it happens with us that we our pitch keeps on fluctuating. Sometimes when we know the answer we have anxiety within ourselves that we will explain it properly and will get marks. So that is convenient from the speech which you are giving to me. Okay, so but if you practice it more, that will be in a balanced way, so that it becomes more alluring to the person who is listening it, rather than he will be recognized. Okay, he has a she knows the answers and she gets excited. Okay, so as a judge, you should be more calm and present. You know that what are the criteria for being a judge. Otherwise, everything is very okay. The more you practice, the more you get can handle this. Okay, out of 100, I have given you 85, expecting a very good ranks. Okay, thank you.
Namaskar, sir. Namaskar.
I'm going to